Ms. Legalista, aka Attorney Sheila here. We are checking out the latest lawsuit that was filed against Diddy by Joy Dickerson-Neal. I understand there've been three, but this is the second one. Remember the one with Cassie Ventura, his partner of a number of years, that got settled within a day. But we're going to break this one down and talk specifically about this whole spiking of a drink that I don't know. She's not really clear about the allegations. She's not really coming right out and saying he did it, but she's hinting that something went on. Let's talk about it.
Yeah.
Here's the lawsuit. If you have not had a chance to look at it, I have another video out there that goes through the whole thing, all of these different allegations that she's making, a little historical background that she's bringing to the table. And she even mentions something about the fact that Cassie stepped forward and, hey, maybe I should step forward too. This is coming out of the state of New York, Joy Dickerson-Neal. I want to go down to this section where she actually starts talking about what happened at this well-known restaurant. And the thing that I guess I sort of want to point out here, just for those who don't have the background on her, she was a student at Syracuse, and she's saying that, he engaged in some activities he shouldn't have. She is one of the people who has brought a lawsuit, a civil lawsuit under the New York Adult Survivors Act, which gave people a break on the statute of limitations for 1 year so that they could bring these lawsuits that may have happened a long time ago and that they wouldn't ordinarily be able to bring. So that actually expired. That act expired 11/24/2023, if I have my dates correct. Now, let's take a look at this part of this lawsuit where she's actually talking about this incident at the restaurant. She had been putting him off, and she says here in paragraph 40, finally, on January 3rd, 1991, during her winter break, Ms. Dickerson reluctantly agreed to meet Combs in New York City. Again, being wary of being alone with him, she chose Wells Restaurant in Harlem, New York, which was a familiar environment as she worked there as a server and knew the employees. It said at Wells, plaintiff began to feel more comfortable as she and Combs engaged in conversation over food and drinks. Later in the evening, plaintiff had to utilize the restroom and left her drink unattended. Now, by just putting this phrase in here, you're sort of implying that something happened because she says she went to the restroom and left her drink unattended. Notice she didn't say anything about her food or anything else. So she is putting this in here to imply that something happened while she was gone. Why? Well, here's what follows. Combs indicated he did not want the date to end and asked plaintiff to join him in doing some errands he had to run around the city. While driving with Combs in his car, Combs produced, as you see there, and asked her to join him with a hit. She politely declined, but Combs was insistent that plaintiff should roll with him and promised to have her home at a decent time so she could study. Feeling pressured, plaintiff reluctantly took a hit. From that point on, plaintiff's memory is incomplete. Now, I talked about this particular sentence in a previous video. I have some concerns about how that is phrased there, but because you're in essence saying to the court when you get ready to testify, if you testify that, okay, so I'm not quite sure what happened. So all of a sudden, everything that comes, around this event is questionable because she has already made this statement that she's not sure. Her memory is incomplete. They can now question everything. So I wish that had been stated a little bit differently. 49 says plaintiff recalls, however, her memory is incomplete, but this much she recalls, Combs bringing her to a music studio. And when she attempted to exit the car, her legs felt rubbery and she was unable to stand. Now, I'm not saying this didn't happen or that it did happen. What I'm saying is when you start this section with, but my memory is complete, you leave yourself open to a lot of criticism about whether you really know what happened next, whether he was the person, where you were, who you were with, when it happened. Is that the right day or are you mixing up your memories? You leave yourself really open to a lot of questions about what's conjecture, what's real, what's truth, and what's not, what's just an error in what you're remembering. Number 50 says plaintiff next recalls being inside of a residence where it seemed Combs was living, except he rang the doorbell. A man who was an acquaintance of both plaintiff and Combs answered the door. Plaintiff recalls that being odd, as she perhaps mistakenly that it was Combs' home. Let me read that again. Plaintiff recalls that being odd, as she believed, perhaps mistakenly, that it was Combs' home. See, again, it's difficult here because what she's trying to do is to say, I was not in my right mind because I believe I was drugged. And that's why I'm having a hard time remembering this. And I'm trying to show you that by laying out certain facts that show you that I was impaired and not of my own free will. But what it also does is it shows that you're leaving yourself open to question now about whether any of this is truth or fiction. And I'm not saying I believe one way or the other. I'm just saying here are some critical concerns about how this was written here. So then it says, number 53, while in the home, this is where the incident took place. Plaintiff recalls feeling humiliated and hurt, yet she could not escape. Why? Because she had been drugged. Plaintiff lacked the physical ability or mental capacity to fend him off. The next day, she hurt in a way she had never experienced before from any of her prior consensual encounters. There you go. I'm just going to leave it there. So now you have what she is implying is that while she went to the restroom, left her drink unattended, that at that point in time, something was placed in her drink. And that as she proceeded to get out of the car later, her legs felt rubbery and she felt kind of weak. Then finally, she was not able to fend him off because she did not have the mental or physical capacity to be able to do that. And I mentioned this well-known restaurant because earlier in the complaint, they actually talk about the history of this restaurant. Just this is this well-known restaurant. For those of you who may be familiar with the restaurant, kudos. It sounds like they had really good food at one point in time. I'm not sure what the status of the restaurant is at this time. But now you have it. Now you sort of know that there was this other piece to it, that she may have been in a condition where she was not able to fend for herself. If you have not had a chance to take a look at the other videos that I've done talking about this particular lawsuit, there is one that goes over the whole lawsuit, and then there are ones that sort of break the pieces down so that we can talk about some of the issues that are presented in a little bit more detail. So don't forget to give the video a thumbs up if this brings you up to speed. Don't forget to hit the notification bell so that you continue to follow everything that I'm talking about. And peace.